to thank you for joining us early enough. Please be sure that you can hear me loud and clear.
Yes, we can.
My name is awesome. Okay, so my name is Nsikan Essien, and I'll be moderating today's session. So today's session basically is a webinar on navigating investments and securities, the Securities Act, looking at the legal, regulatory, and governance implications. We all know that the Act was passed this year, and it was indeed a bold step for the modernization of the capital markets. But just a few house rules before we begin. Please, can you kindly mute your microphones if you're not speaking, and turn off your cameras as well to enable us to have a hitch-free session. You can also, if you have questions in the course of the various sessions, please insert your questions in the Q&A box right there at the bottom. We would also ask that you use the comments box if you have any other questions for our attention in the course of this session. So with that said, I would like to, and without any further ado, I'd like to introduce Dr. Ernest Shonekan Centre for Legislative Reforms and Economic Development to deliver the opening remarks, which would definitely set the tone for today's meeting. Dr. Bona, over to you.
Hey, good morning. Thank you, Nsikan. Thank you, every other person who has joined this session. Let me say welcome to everybody to this event. Good morning, distinguished colleagues. Good morning, partners, friends of the Ernest Shonekan Centre, and friends of the NESG at large, and then all other participants who have joined this discourse. On behalf of the board and management of the center, I warmly welcome you all to this important webinar on navigating the Investments and Securities Act. Over the years, ESC has built a reputation for bridging the gap between legislative intent and practical implementation. We take complex legal and policy provisions and translate them into clear, actionable guidance, both at public and private sector, so that both public and private sector stakeholders can apply. In summary, I would say the center is an apostle of simplicity. The ISA, the Investment and Securities Act, is the most far-reaching reform in our capital market legal framework in the last couple of years. The investment it has redefined regulatory oversight, strengthened investor confidence. The way we implement this act will shape Nigeria's economic and sorry, please, I have a little. So why are we here today? The ISA has significant implications for regulators, for lawmakers, for the judiciary, market operators, and legal practitioners at large. What is our focus? We want to identify the major reforms in the ISA, understand their implications for oversight, explore compliance possibilities, and then engage with peers and experts on strategies for effective implementation. We have an expert panel cut across different sectors, from the regulatory to the private sector and the practitioners as well. Definitely their perspectives will help us not see the letter of the law, but also the real-world strategies needed for compliance, enforcement, and governance. Why does this engagement matter? The ISA would influence quite a lot in our business environment. How we raise capital, and how we protect investors, how regulators enforce rules and manage risks, how we position Nigeria in the global investment landscape. And this is very key for attracting the FDIs. So your active participation today, asking questions, sharing insights, and highlighting sector-specific challenges will ensure our understanding is deep, practical, and ready for application. As we go through these sessions today, I encourage you to think about one action you will have after this webinar, whether it's advising an organization for more effective investment, strengthening our compliance system, or engaging the policymakers to improve implementation. If we live here informed, connected, and ready to act, we will have advanced the goals of the ISA 2025 as designed to achieve stronger markets, greater investor confidence, and a more competitive Nigeria. So on behalf of the board and management of the center, I thank you all for joining, and I'll say welcome once again. We look forward to your active participation. Thank you very much.
Thank you very much, Dr. Ogbonna, for that insightful and inspiring opening. Your remarks have set a powerful tone for today's discussions. This basically is a reminder of the critical role that the ISA will play, in shaping the capital markets in Nigeria. Let's now turn to our first speaker, who is Mrs. Franca Egweke. She will be taking the session, The Big Picture, Key Provisions of the ISA 2025. And I believe that just to further introduce Mrs. Franca, she is an Associate Director, Legal with the IHS, and she brings a wealth of experience from working in the capital market sector. So, Mrs. Franca Egweke, you're welcome.
Thank you very much. Can you hear me?
Yes,
Loud
very
and
clearly.
Okay, perfect. Good morning, everyone, and thank you very much, Dr. Ogbonna and Mr. Khan, for setting the tone for the session. I think someone was supposed to assist with the slides. Okay. Good. Thank you. So I'll be taking the session on, like Nseka introduced, on the big picture, essentially focusing on the reforms that have, the major reforms that have been introduced by the Investments and Securities Act 2025. Now, in introducing the session, I think I will just pretty much say that the ISA has made significant, the ISA 2025 has made a number of significant changes, reforming the previous provisions that we had in the 2007 version of the Investments and Securities Act. And pretty much I would just by way of summary say that all of those reforms that have been introduced in the 2025 ISA largely are geared towards enabling the SEC, which is the apex regulator of the Nigerian capital market, to actualize the objectives for which that institution has been established. And some of those objectives include the protection of investors, ensuring that we have market integrity in our Nigerian capital market, and of course, fostering economic development. Can we go to the next slide, please? Now, in helping the next slide, in helping the investment, good, thank you. In helping the Securities and Exchange Commission to actualize its objective, it's important to state that the ISA 2025 does not just, set the enabling provisions for the SEC to achieve its objectives, but it went a step further to actually make provision for practical tools that will enable the SEC, towards attainment of these key objectives in the capital market. Next slide, please. So before we move into the key reforms that have been introduced by the 2025 ISA, I think it's important to take some steps backward, right? Just so we can understand some historical context in terms of the journey from the 2007 Investments and Securities Act, which repealed the 1999 ISA, before then getting into the 2025 ISA. Incidentally, this is a webinar. We're very conscious of time, so it would almost be impossible to go take a deep dive into all of the provisions that have been set out in the Act. However, we will try as much as possible to, focus on key highlights, and then hopefully at subsequent sessions we can have more time to take deep dive into analyzing each of these provisions. So on that note, I would start by saying or acknowledging the fact that the 2007 Investments and Securities Act was indeed, a legislation that did have quite a number of important provisions, so acknowledge that fact. However, considering that that legislation was almost 20 years old, I think precisely 18 years, so you would imagine that quite a number of transformations would have gone into the market for which a 2007 legislation would not be able to address. And so obviously the 2007 ISA had a number of limitations after going through the course of this almost 2-decade period. And what are those what are those limitations that we can attribute to the 2007 ISA? First, I have here that there's a lack, or that there was a lack of comprehensive legal framework for emerging topics. Like I did say at the beginning, the act was almost 20 years old, and so naturally you would expect that quite a number of transformations had happened. And to make it even more interesting, the ISA was packed in 2007, and just 1 year after, some of us here might remember the 2008 global financial crisis that occurred, and the dramatic effect it had on different economies across the globe. So starting with the 2008 global financial crisis, it was really important that, there was a need to have a new law that would address some of those issues that occurred. The global financial crisis, of course, started in the US with the Lehman Brothers case, which, at some point in the course of their business, they had to file for bankruptcy, and the US government could not, or rather refused to bail them out. Lehman Brothers happened to be, I think, about the 4th largest investment bank in the United States of America at the time. And so because of some of the excesses in the market due to them giving out loan to investors or customers who actually could not satisfy the required criteria for those kind of loans, the subprime mortgage, they had to then go into a default exercise, and that kind of created a whole lot of systemic risk in the economy, which trickled down and permeated across various jurisdictions. Nigeria was not an exception, because we did have quite a number of foreign investors at the time. Prices in the stock market started going significantly down, and this was largely driven by the fact that foreign investors were pulling out their funds from our markets. And so the panic that created in the market started forcing the prices of the securities on the exchanges to start, going southwards. There was a lot of panic, there was liquidity crisis, and all of those havoc in the market. And so also coupled with the fact that the oil prices were going down significantly at the time. So imagine with all of those hazards that happened, a lot of investors lost their means of livelihood. Investors lost most or all of their assets. Some investors even had to, pass on because of those sort of major losses that hit them hard. So talking about legal framework, I mean, at the time these crises were happening, what could the regulator have done? Obviously little or nothing, right? Because the regulator would naturally allow the market to take its turn. But interestingly, with the 2025 ISA, what we then see is that the ISA has now provided enabling provisions for the apex regulator to step in the event that there's a systemic crisis in the, Nigerian capital market. So the SEC would step in to stabilize the market, and this could be through measures like, stopping or ordering that trading in some securities should be stopped or suspended rather. And this could even cut across all of the securities that are traded across a particular exchange, just to curtail some of those excesses and prevent a contagion of the systemic risk that would have occurred. So closely related to the global financial crisis was also the fact that there was the need in jurisdictions like ours to start establishing business structures like financial market infrastructures that would absorb some of these systemic shocks that occur in the markets. And that's why subsequently we did have companies like central counterparties, which we abbreviate to CCPs. Today we have about CCPs in the country. Thankfully, I was privileged to have been a founding employee of one of the CCPs, NG Clearing. And what's the major role of such an organization is largely to ensure that there is a guarantee around settlement of transactions that happen on an exchange and annovated to the CCP for settlement and clearing. So the CCP provides an assurance or a guarantee that any trade that goes through its platform will definitely be settled. And in an unlikely event that there is a default, the CCP is able to utilize its default management mechanisms to, absorb some of those losses and stabilize the market. So again, with such a structure existing, there was no legal framework in Nigeria to enable the establishment of such a structure. And so it took quite some time, the SEC bringing out rules, I think sometime in December 2019, and subsequently the Companies and Allied Matters Act that was passed in 2020 that provided certain netting and settlement provisions, which was, like a stopgap for the lack of a statutory framework. So here we are today with the 2025 ISA containing robust provisions for licensing and regulating the operations of CCPs and other financial market infrastructure. And then we had limitations around the enforcement powers of the Securities and Exchange Commission, and closely related to that is the fact that even the penalties that were provided in the 2007 ISA were not strong enough or stiff enough to deter, prospective or fraudulent participants in the market from getting involved in some of those crimes. And so you can imagine a participant in the market committing a fraud that could make an individual investor lose 1, 2, 3, 4, 5, 10 million or more. And at the end of the day, our law was providing for a penalty of, say, 100,000 naira, bearing in mind the time value of money and the fact that that money was just a nominal amount that would not necessarily deter a fraudulent person from participating in such fraudulent activities. So yes, so having noted some of those limitations in the Act, the question is then why do we then have the 2025 Act? Again, I think it goes without saying, having highlighted the gaps that we have gone through in the previous slides. We talked about the emerging markets in the likes of the financial market infrastructure. There's also the commodity business, which is gradually, evolving to, at some point take over from what used to be the Nigerian oil revenue, right? So the economy or the country is now de-emphasizing the oil revenue and looking inwards to things like commodities, particularly the agricultural sector. So there are emergence of commodity exchanges in the market, quite a number of them. Recently, the SEC and the NMDPR licensed a gas exchange, and we do know that there are quite a number of other commodities that have exchanges springing up to cater to their businesses. We also have, emerging issues like climate risks that we keep hearing across the globe. Companies now investors are gradually becoming aware of the importance of ESG and sustainability issues, and the fact that companies that are driven by this sort of governance standards, have some positive impact in their businesses. So investors are naturally attracted to those kind of businesses. And that's why today you find out that quite a number of regulators, both locally and foreign regulators, now ensure that as part of regulatory requirements, they expect participants or regulated entities to file some sort of sustainability reporting practices in their organization and put some of those checks. We also have emerging areas like the AI, which is the buzzword of today. We have a lot of fintechs coming up with different platforms for transactions. We have digital assets, cryptos, and all of that. In the recent past, the CBN were aware had actually put some kind of ban on transactions around that area, but thankfully the SEC took a bold step subsequently to regulate that business, and today that regulation is now being codified into 2025 ISA. Next slide, please. So yeah, the key drivers for the ISA 2025 reforms, I don't think there is really need to start reiterating some of the things I had mentioned in the past. But suffice to say that in terms of the expansion of the product range in the market, we now have the SEC having regulatory purview, or rather clarity in the regulatory purview of certain businesses that would constitute collective investment schemes. So new fund structures are, generally now being embedded under collective investment schemes, and the Act now clearly defines CIS to include both open-ended and closed-ended schemes, and that would then mean that with the new structures and other existing structures like private equity funds, venture capital, and all of those sort of fund mechanisms are now clearly statutorily being regulated by the Securities and Exchange Commission. And of course, we have other assets like the derivatives, which have also been launched in Nigeria. I've spoken about sustainability and ESG. I think another driver is the fact that there was a need to, expand the jurisdiction or the regulatory scope of the Securities and Exchange Commission to go beyond the shores of Nigeria. And that's because you do have transactions that actually originate or emanate from outside the shores of Nigeria. However, they are targeted to Nigerian investors, and some of those transactions end up being fraudulent. And so our innocent investors in our jurisdiction, fall victims of some of these fraudulent activities. So you see a lot of crowdfunding schemes now online, just coming up from different jurisdictions. So the SEC is now able to actually regulate by virtue of the powers that have been granted to them in the new Act. SEC is able to regulate all of those sort of transactions that happen, whether online or physically, whether within Nigeria, whether originated in Nigeria or outside Nigeria, but to the extent that it's targeted towards Nigerian public, the SEC actually takes jurisdiction over that regulatory powers. And we do recall that, the powers of the SEC, like I mentioned at the preliminary slide, have also been expanded. And of course, there was a natural need for that, based on some of the things that I had highlighted and the need to protect investors. Next slide, please. So having gone through the historical context and also understanding some of the drivers for this change, what then are the reforms that have been introduced by the 2025 Investment and Securities Act? I think one of the major reforms is the fact that the Act now designates the independence of the Securities and Exchange Commission, and that's really a very welcome development, because what it then means is that our apex regulator would have independence in executing their functions with no interference from external forces, be it political or otherwise. And there's also the fact that the Act now empowers the SEC to collaborate with foreign regulators in carrying out its own functions. So just like the issue of crowdfunding that I mentioned, where this could have originated from outside Nigeria, this is a provision that would enable SEC to actually call those people and get them to book. So in the course of regulation, it can collaborate with the foreign regulators in the respective jurisdictions where these transactions emanate from, and who will then assist with respect to things like freezing of assets and similar regulatory actions that will be taken by SEC. And it's important to say that this independence and international collaboration kind of reinforces the signatory A status of the SEC under the IOSCO enhanced multilateral MOU. And IOSCO, as we know, is the International Organization of Securities Commissions, securities commissions across various jurisdictions. And one of the major criteria that they do emphasize is the fact that you need to really collaborate with regulators from other countries. So this kind of gives credence to that status that SEC has already attained. Next slide, please. So other reforms that have been introduced by the ISA 2025 also, I think, has spoken about introduction of, or rather innovation of new types of securities like cryptos, which in fact are now effectively being classified as securities under our new law. And we have, the digital asset operators, exchanges, and I think what I should actually mention here is the fact that this creates benefits for everyone in the market, because you have expanded product range and activities in the market will create more market depth, and participants obviously will be well governed, because the SEC has actually churned out comprehensive provisions for regulating these entities to ensure that they have governance practices. They have provisions and practices that speak to cybersecurity, protections, measures, and things around AML checks and all of those. And ultimately, that also means that the protection of investors, is reinforced, and investors would, of course, continue to have confidence in the market. Next slide, please. So other reforms, I talked about the enforcement powers and mechanisms of SEC previously, but I think I should take a minute to, speak about some of these enforcement mechanisms. So SEC today is able to investigate, activities and move very swiftly, so the SEC can actually enter into a premises and seal up the premises, freeze assets, and demand forfeiture of assets emanating from some of these fraudulent activities. I think at this point, it would be good to mention that one of the, very prevailing fraudulent activities we've had in our market is this Ponzi scheme that comes in different forms and shapes. Some of us might remember the MMM that happened, I think, sometime in 2016, which led to a loss of over $100 million globally of investors' funds. And that was actually a Ponzi scheme that originated from Russia. A lot of investors lost significant amount of their funds into that scam. We also had the recent case of the CBEX in Nigeria, which was this digital asset exchange, that was not registered and was not regulated. And like you would expect, eventually it crashed, leaving investors to lose over over 1.3 trillion naira in the economy. So you can imagine the quantum of losses that investors do encounter whenever these fraudulent activities come up. And without having a clear provision as to even prohibiting these crimes, it poses a lot of limitation on the side of the SEC as the regulator. So the Act now actually empowers the SEC. In fact, it doesn't just prohibit such fraudulent transaction, but it empowers SEC to move very swiftly in the event that they discover these fraudulent activities happening, especially where they have not been registered. Obviously, they wouldn't even be registered if they are fraudulent. So, and how does the SEC do this? I think I should mention that in the past, the SEC would rely a lot on, court procedures, and with all due respect to our judicial system, we are very familiar with our repeated adjournments and how, litigations can be quite frustrating in the course of prosecuting offenders or criminals. And so that kind of poses some sort of limitation on the hands of the regulators. But in our current Act, the ISA 2025, the SEC has actually been empowered to issue administrative fines. So rather than waiting and chasing the courts and the court processes and the adjournments and all of those, the SEC can actually move very quickly to slam a fine on these offenders, and can actually go a step further to ensure that they are enforced. And then another interesting introduction is the fact that the SEC can now collaborate with key stakeholders like the telecom companies and then the internet service providers to get data or critical information, whether by phone call or messages that have been exchanged by some of these fraudulent persons in the market, which would then enhance the investigative mechanisms that they adopt to to get to the culprit. And I did talk about sanctions at the beginning of the session, where I said we now have significant sanctions fines now range from 5, 10 million, 20 million, depending on what the nature of the offense is. And let me also pause here to say that these fines are actually huge, yes, but the rationale really is not necessarily to punish, even though it will punish. But I think the major objective I should highlight is the fact that those fines have been put here because we need them to serve as deterrents to the potential fraudulent persons, so that when you see the amount you're likely going to be coughing out in addition to all of the assets and the funds you have raised being seized and forfeited, you will think twice before getting involved into some of those fraudulent transactions. Yeah, next slide, please. So other key reforms I had already mentioned in the course of talking about the limitations of the ISA 2007, that the regulatory scope of the SEC has been expanded both from a product perspective as well as a territorial perspective, because the SEC now has regulatory purview over all of those innovative products that have come into the market, as well as being able to exercise cross-border regulatory powers, and also with the support of the foreign regulators who the SEC would collaborate with in this regard. Next slide, please. So key reforms, we continue on that subject of comprehensive legal framework for the financial market infrastructures, which I already talked about when I discussed the role of the CCPs in the market and other market infrastructure. It's important to clarify here that we do, or rather the 2007 ISA actually did have legal framework for entities or market infrastructures like exchanges. However, the reform in the 2025 version of the Act is the fact that the exchanges have now been classified into composite and non-composite exchanges, such that the composite exchanges are the exchanges that would allow trading of all kinds of securities on the platform, as against a non-composite, which would only be able, by virtue of the license that will be issued to the exchange, to trade only a type of security. So, for instance, you could decide to trade commodities or equities or bonds or other similar asset class. And of course, the non-composite could be either mono or alternative trading system. I talked about commodity exchanges. I think the other thing to mention there is the fact that the warehouse receipts that are being issued by the commodity, the warehouse operators, are actually now regarded as securities that you can trade right on the floor of exchanges. And was that for me?
Yes, please. So you have just 3 minutes.
Okay. So yeah, so I talked about FMIs, and I think I should mention that the Act provides for insolvency protections for FMIs, and under previous legislation or even existing legislation like Companies and Allied Matters Act, we know that we have wide provisions on insolvency, which could jeopardize the business of market infrastructures like central counterparties, where a liquidator, for instance, would be able to cherry pick in terms of the assets that it's recognizing, improving the debt of the assets of a company that has defaulted, and probably filing for a winding up proceeding. Now, the liquidator is able to, or under current laws, or rather insolvency laws, to disclaim onerous property transactions and similar powers. The liquidator actually had wide powers, but the 2025 Investment and Securities Act has now excluded the market infrastructures like CCPs from being subjected to those insolvency provisions that are under insolvency-related laws, as those contained in CAMA and similar provisions. In terms of registration of self-regulatory organizations and trade association, that has now also been codified in the law. hitherto regulators would have different SROs and trade associations coming up, and these associations can be quite disruptive at public meetings like annual general meetings. However, with the codification now in the law, they are now mandatorily required to register with the SEC just so that they can properly conduct their affairs and ensure that their members are also well conducted and do not exhibit unruly behaviors at public functions. There's also the requirement for mandatory LEI, which is like an alphanumeric number that is issued to participants in the market, just to enhance the transparency and traceability of those participants that undertake transactions. Next slide, please. I talked about systemic risk and the function of the SEC in managing systemic risk. So closely related to that is that SEC can actually request for information proactively from market participants, if it senses any of these things. And of course, where there's a systemic crisis in the market, they can step in to stabilize the market, to forestall things that led to the global financial crisis that happened in 2008. In terms of investor protection, the IPF, which is the Investor Protection Fund, has now been expanded, right, to also provide compensation for losses that are incurred by investors, as a result of cancellation of the licenses of the brokers or daily member house that they were transacting through their platform. Unlike the previous act, which did not have compensation in the event of a cancellation of license. I think it was limited largely around bankruptcy and insolvency of the daily member. But now, if the regulator revokes the license, investors who trade through that house would actually be compensated from the funds. Next slide, please. So borrowing, I will not spend much time here, but just to say that the Act also makes provisions for borrowing by both government and corporates, and there are stringent requirements or conditions that have to be met, which include making sure that you have sinking fund and the irrevocable letter of authorization for that transaction. There are also punishments for diversion and mismanagement of funds. And also one of the borrowings that have now been introduced is the borrowing that is being undertaken by an entity that is sponsored or guaranteed by a government agency. Next slide, please. So the IST, again, I will not spend much time here because I believe one of the speakers will be speaking to this subject matter, but what I would just mention here is that a few changes have been made, including expunging the requirement to pay fees into the funds that have been established, for the IST. And this is largely because the fees are now being paid, fees to government, are now being paid through the remitter platform directly to the government. So it doesn't really go into the funds of the IST anymore. IST jurisdiction, of course, have been clarified by the Act as well. In the past, you would be required to register a judgment of the IST with the Federal High Court, but now that has been expunged, so which kind of reaffirms the jurisdiction of the IST to be at par or as peer with the Federal High Court, such that any appeals will then continue to go directly to the Court of Appeal. And lastly, the fact that lastly on this point is the fact that the IST now has power to commit, for contempt committal for defaulters. And then there are regulatory clarity around corporate restructuring for public companies in the light of the FCCPA Act, that now regulates competition-related practices in the market. There's also clarity around treatment of unclaimed dividends of public companies, which previously we had regulations issued by the SEC, but those regulations more or less have now been recognized statutorily. So the issue of dividends of public companies can now be addressed by remitting them into the funds that have been established for that purpose after a certain period of time. Next slide, please. So I think the last major reform is just some of the miscellaneous provisions that the Act has introduced, and this includes the requirement to issue mandatory notice to SEC. I beg your pardon, I should have included SEC there. So any person wanting to sue the regulator would have to actually give them a notice of at least 14 days timeline before you can proceed to sue the regulator. And then there's an omnibus penalty clause such that if there's no penalties specifically identified in the act for any particular offense, the SEC can fall back on this, and there are penalties for other acts which I've also highlighted here. In the interest of time, I think I can just skip to the last slide. So yes, what are the implications for the Nigerian capital market, given all of the reforms that have been introduced? It goes without saying that the apex regulatory status of the Securities and Exchange Commission will continue to be reinforced by virtue of those provisions. And of course, we do have our markets now aligning best practices, with things that happen across the globe. And of course, we talked about, or I did mention, the collaborative approach that the SEC now adopts to foreign regulators. All of these reforms would, of course, boost investor confidence, attract foreign investors, ensure that we keep having dynamic products in our market, and last but not the least, to enhance the market integrity and the stability of our financial system. Thank you.
A round of applause for Franca for that very comprehensive review of the ISA 2025. Please just use your icons to give her a round of applause. I think she did that. She delivered that within a very short period of time. And your presentation indeed reinforces the ISA's role in strengthening the Securities and Exchange Commission's position as the apex regulator. And the Act has definitely solved some of the major concerns of investors. So this in turn improves the business environment. Thank you again, Franca. So at this point, we would like to invite Mr. Odiaka Vincent Iweze. So our next session basically will turn the spotlight on legal oversight and investor protection. These are basically two pillars that are essential to the credibility and fairness of any capital markets. So our speaker, Mr. Odiaka Vincent Iweze, is the president of the Capital Market Solicitors Association. He's also the co-founder of Pentagon Partners Legal Practitioners, where he leads both the dispute resolution and capital markets team. So Mr. Iweze will be sharing some key insights on the legal oversight and investor protection perspective of the ISA. Over to you, Mr. Iweze.
Thank you so much, Nsika. Good morning, distinguished guests, ladies and gentlemen. Nsika, can you confirm if you can hear me, please?
Yes, loud and clear.
Thank you so much. Well, it's my absolute pleasure to join everyone today to discuss the Investment and Securities Act 2025 and to contribute to the virtual webinar themed Navigating the Investments and Securities Acts 2025, Legal, Regulatory, and Governance Implications. The ISA 2025 marks a comprehensive overhaul of Nigeria's principal legislation governing investments and capital markets in Nigeria. To borrow the words of Dr. Agama, the DG of the SEC, he said, the ISA is a game changer that has the strong potential for stimulating growth for the Nigerian capital market and the economy. My sincere thanks to the Ernest Shonekan Centre for this kind invitation and for providing this platform. I see that I have 20 minutes, and today I'll be speaking on legal oversight and investor protection. Just let me know if you can see my screen while I share my slides.
Yes, I can.
Okay, thank you so much. So our roadmap today is in two broad forms, which will be, first of all, I'll be talking about the Investment and Securities Tribunal under the ISA 2025. Then I'll be highlighting 8 investor protection reforms that can be seen under the ISA 2025. Disputes are inevitable, and the capital markets is a very unique area and requires specialized information. As a result, the ISA has created the Investments and Securities Tribunal and equipped it with judicial officers that understand the workings of the capital markets. So Part 17 of the ISA, in particular sections 314 to 319, deal with the ISA. Now, the ISA is established by virtue of Section 314, sub 1 of the ISA 2025, and it mandates the IST to exercise the jurisdiction, powers, and authority conferred on it by the ISA. Now, the composition of the IST, I'll now use interchangeably, either the IST or the tribunal. It consists of 12 persons who are appointed by the President of the Federal Republic of Nigeria on the recommendation of the minister. And the minister in this instance refers to the Minister of Finance. Now, the chairman is a legal practitioner who must have 15 years post-call experience in capital market matters. Other members are 5 full-time members, 4 of which are legal practitioners and must have 10 years of post-call experience in capital markets, and 1 other person who is not a legal practitioner but must have 10 years experience in capital market matters. The other members, which are 6 in number, are part-time members, 2 of which are lawyers, 10 years post-call experience in capital market matters, and 6 others who must have 10 years experience in capital market matters. The minister also has the power to recommend to the president any disciplinary action against the chairman and other members in the unlikely event that there's some disciplinary issues. Now, Section 335 confers exclusive jurisdiction on the IST on all matters that are specified in the Act. So in other words, any issue as it relates or that is stated in the ISA, it is the IST that has exclusive jurisdiction over such matters. Now, going further, Section 326, sub 1 says that the tribunal has exclusive jurisdiction to adjudicate on disputes arising from investments and securities transactions in Nigeria. So in addition to the jurisdiction with respect to matters specified in the Act, it also says that any issue around investments and security transactions, it is the IST that has exclusive jurisdiction over any other court. Now, the jurisdiction is original jurisdiction and appellate jurisdiction. Now, for original jurisdiction, it simply means that it's the court of first instance with respect to 3 matters or 3 issues that have been clearly stated in Section 326, sub 2 of the ISA 2025. So for the tribunal to exercise original jurisdiction, first of all, it must be a complaint against the direct action of the commission, which is the SEC. So if there's a complaint against an action that the SEC has taken against you, the IST is the place that you will file your case against the SEC. The second one is a matter which had been referred to the commission and the commission has failed to act within 60 days. So if you had referred something to the SEC and after 60 days there was no response from the SEC, then you have a recourse against the SEC directly at the IST. And the third is the matter arose from a regulatory action taken by the SEC under the provisions of the Act. Now, Section 326, sub 3 now provides for the appellate jurisdictions under 3 headers. Now, with respect to disputes that have been expressed in the ISA 2025, disputes such as the capital market operators issues or issues between capital market operators and their clients, all of these will fall under the appellate jurisdiction. The other 2 are issues arising from the administration, management, and operation of collective investment schemes and relating to the review, approval, and regulation of mergers, takeovers, and restructuring of public companies. It is the IST that has appellate jurisdiction over these issues. Now, it's important to state that in the case of Ajayi versus SEC, the issue or the conflict with respect to the Federal High Court as regards jurisdiction was resolved by the Supreme Court. Now, what had happened in that case was that African Petroleum, AP, had sold about 84,000 shares of its shareholding in AP. And the core investor, upon taking over, now realized that there was a material non-disclosure as regards to the debts that were actually being owed by AP. while 10 billion had been disclosed in the prospectus, they actually found out there was an extra 22 billion that was being owed. So Mr. Ajayi was the finance manager and the person responsible for signing off on the prospectus with respect to amounts that were being owed. So there was an investigation by SEC, and this was now taken to the APC. And the APC came up with a ruling indicating that Mr. Ajayi should be sanctioned, and there was enough material for him to be referred to the EFCC. Now, at that point, upon being served with the ruling by the APC, Mr. Ajayi now wanted to appeal the APC and went directly to the Federal High Court. The SEC raised an objection indicating that the proper court that would have appellate jurisdiction was the IST. Now, this went all the way to the Supreme Court. So even though the Court of Appeal gave judgment in 2007, it was not until 2023 that the Supreme Court finally gave its judgment indicating that the proper court that would have jurisdiction with respect to investment and securities transactions will be the IST. So the Supreme Court indeed has resolved that issue. Also, the tribunal will have jurisdiction with respect to other matters as may be prescribed by the National Assembly. Now, the jurisdiction of the IST relates only to civil matters. In other words, the IST is a civil court for all purposes and will not have jurisdiction with respect to criminal issues. Criminal issues will therefore be filed before the proper court that has competent jurisdiction. However, one of the innovations of the ISA 2025 is that lawyers who now work with the SEC are able to represent the SEC before any other court. And importantly, these lawyers are able to prosecute criminal matters before courts of competent jurisdiction, as well as defend any criminal matters, as long as they have the consent of the Attorney General of the Federation. Now, before you can exercise or commence any action before the IST against the Commission, Section 331 and 341 mandates that you must give the Commission pre-action notice. So it says before commencing an action, in other words, before you exercise the original jurisdiction of the IST or appealing, in other words, the appellate jurisdiction as we had indicated, you must give the Commission 14 days notice of intention. You must state the plaintiff, name of the plaintiff, the cause of action, and the relief sought in that regard. Now, with respect to the appellant jurisdiction, in other words, where you believe that your action falls within the appellate jurisdiction of the IST, you must file that appeal within 30 days. Now, in the unlikely event that you can't file that appeal within 30 days, in your motion seeking leave to extend time, you must show sufficient reason as to why or what caused that delay in order to enable the IST, grant your application for extension of time. Now, also the ISA 2025 mandates that the tribunal must resolve matters within 3 months of substantive hearing. Now, that point is very important. Not 3 months from when the case is filed, but 3 months from when the hearing of the matter has started. However, there will be such a judgment, if given after 3 months, will not be void because of such a delay, unless it can be shown that there's a miscarriage of justice. The ISA, in particular, Section 336 provides that appeals from the IST will lie directly to the Court of Appeal. However, it provides 3 conditions or 3 scenarios within which you can proceed from the IST to the Court of Appeal. The first is that the decision taken in exercise of its appellate jurisdiction on points of law only. So in other words, where you exercise the appellate jurisdiction by filing a case before the IST under the appellate jurisdiction, and the IST gives a decision, you can only appeal to the Court of Appeal if it's on points of law only. However, if it's on points, or if it's mixed law and facts, then, and it was from the appellate jurisdiction, you're unable to proceed to the Court of Appeal. It means that the IST will be the final point in that scenario. The second scenario is if it's a final decision taken in exercise of its original jurisdiction on points of law or mixed facts. So where you file under the original jurisdiction for the 3 points that I had raised earlier, then you're able to proceed to the Court of Appeal on points of law or mixed law and fact. And if it's an interlocutory decision that is being appealed against, it's only on points of law that you can proceed to the Court of Appeal. Section 337 indicates that appeals from the Court of Appeal will lie also to the Supreme Court. However, it doesn't provide any conditions upon which such appeals will proceed to the Supreme Court. In this instance, it will be the 1999 Constitution that will guide any such appeals that are proceeding to the Supreme Court. The ISC 2025 also says that the tribunal has powers to make rules regulating its procedures. So in other words, the IST has the power to amend its present rules now to conform with the ISC 2025. Also, the tribunal has powers to hold proceedings in camera, and what that simply means is in private, where it deems such appropriate. And Section 332, sub 2, lists the powers of the tribunal. And as Franca had indicated, it also now has the power to commit people to contempt, dismiss application for default, to set aside orders, and to do anything in its opinion that is incidental or ancillary to the functions under the Act. Now, as I round up on the IST, I thought it was important to bring these two sections to the forefront and see if there's a conflict. Now, Section 341 sub 1 is very clear, and it says that a suit shall not be commenced against the Commission before the expiration of 14 days after written notice of such intention to commence the suit, which shall be served upon the Commission by the intending plaintiff or his agent, and the notice clearly and explicitly state the cause of action, the particulars of claim, and the name and address of the intending plaintiff. This clearly is a pre-action notice that must be given to SEC before an action can lie against SEC. However, Section 331 sub 2 is worded a bit differently. Now it says an action or appeal shall not be commenced at the tribunal or in any other court in respect of anything covered under this Act, unless the aggrieved party has given to the Commission at least 14 days written notice of his intention to commence the action, and the notice will state the cause of action and the name of the aggrieved party. Now, a few questions come about. Now, is the implication meaning that if I intend to sue any other party, for example, under the appellate jurisdiction, that does not involve the Commission, but a capital market operator or investor or an issuing house, do I still need to notify the SEC before that action can be taken before the IST? Also, it says in any other court and also if you're filing an appeal. Now, does that mean that the word appeal here extends beyond the appellate jurisdiction of the IST, such that before I can file at the Court of Appeal, which can be seen as any other court, I need to give notice, 14 days notice, that I'm about to file an appeal before the Court of Appeal? I guess it will be interesting days to see how these sections will be interpreted by the courts. Now we'll proceed to investor protection reforms under the ISA 2025. And what I'm going to do is highlight 8 key points that show that the ISA 2025 is key on protecting investors within the capital market ecospace. And we'll start from the long title. If you look at the long title of the Investment and Securities Act 2025, you'll see that one of the key points stated there is the protection of investors. Also, in recent times, the SEC has taken upon itself on its website to begin to warn the public about companies that are not registered by the SEC, or that are asking for investments, or that are just illegal entities. And that can be seen at sec.gov.ng/category at illegal investments. So one of the first things that the ISA does is to ensure that there is investor education. Section 3, sub 4, sub Y empowers the SEC to promote investor education and training of all categories of intermediaries in the security industry. Platforms like these serve as such platforms that where we educate investors. Also, the SEC is here, and that shows the importance it places on such programs like this in ensuring that investors are educated. Also, the Act mandates that managers of collective schemes have a duty of educating investors. And the essence of educating investors is so they know their rights, they understand what they are getting to, and they understand the implications of the kind of market they are coming into. And secondly, the ISA ensures that the SEC can combat systematic risks and also put an end to illegal schemes. As Franca had said earlier, Ponzi schemes have been a menace in society. She had mentioned CBEX, also the P1 issue that had come up recently, and there's a list of investment companies that are provided or stated under the SEC Act, where it clearly says that these companies are not registered and have no right to begin to ask the public for investments. This is because of the powers that have now been conferred on the SEC by the ISA 2025. Also, by virtue of Section 82 of the ISA, the SEC can now be proactive. It now has powers where it suspects that, look, the actions of a certain entity can bring about systematic risk to the ecosystem of the capital markets. It can now begin to ask and demand for information from such an entity. It also can, on the application of any other financial regulator, demand information from companies just to determine that actions being taken by these entities will not bring about a systematic risk to the entity, to the capital markets ecosystem. And where it now sees that this may happen, the SEC now has powers to put in certain sanctions. And where there's a refusal by entities to release certain information that has been requested by the SEC has powers to issue penalties. In fact, it says penalties of no less than 20 million naira and 50,000 naira for every day of defaults. Now, the third thing we'll be talking about will be the criminal liability for market abuses. And in particular, we're going to be talking about trading of securities under sections 132 to 139. Now, Section 132 prohibits false trading and market rigging. And this simply means that people are stopped from giving the impression that a certain security is being traded. So you don't wake up one morning and you begin to believe that, oh, a certain security is being traded and you think it's lucrative. Meanwhile, this is a deliberate attempt by certain persons where there's no transfer or actual sale, but you want to give an impression to the market that, oh, this particular security is hot at the moment. And Section 133 also prevents participants within the ecosystem from giving false and misleading statements while trading in securities. Also, people are prevented from fraudulently inducing transactions. Again, like I said, from giving impressions that, oh, this particular security is being traded when in fact it's not being traded. Also, dissemination of illegal information, that information that is not true with respect to certain securities, and also insider trading are all prohibited. And all of these are done to ensure that investors are adequately protected. Section 139 clearly states civil and criminal liabilities that will accrue to persons that are found erring under sections 132 to 139. Now, it's interesting to note that section 348 clearly says that any penalty that has been issued by the SEC shall be treated as a debt. In other words, once SEC has issued a penalty, it now has a right to go to court through any of his lawyers working within the SEC to now sue for that amount and recover any penalty that has now been placed on such a person. We also have the whistleblowing. Whistleblowing is an act of reporting potential securities law violations, corporate fraud, or illicit activities within the financial industry to SEC. Whistleblowers provide crucial information that helps protect investors, maintain fair and transparent markets, and hold wrongdoers to accountability. So the ISA now provides a platform for whistleblowers to cooperate with the SEC. But the most important part is that such whistleblowers, one, are able to get some form of compensation for whistleblowing, and importantly, protection under the Act from any blowback. This is important and gives whistleblowers the confidence that when they come forward to report any infractions, they will not suffer any negative consequences by their employers. Also, Section 123 provides for the legal entity identifier. Now, this is defined in Section 357. It means that's a code that uniquely identifies every distinct entity or structure that is a party to a financial transaction. Now, this is done to ensure that there's accuracy of financial data. It also enables identify every person within the ecosystem and can prevent any anonymity within the control of shares and hide any ownership. We're now moving forward to investor protection. Now, sections 198 and 223 provides for the Investor Protection Fund. It says that each securities exchange shall maintain a fund, which is known as an Investor Protection Fund, to compensate investors for losses caused by insolvency, bankruptcy, or default of a dealing member, by fraud by dealing member, and these funds are administered based on guidelines that are issued by SEC. Now, one of the things that the ISA has done towards also protecting investors is through the introduction or expansion of its scope with respect to forex trading and virtual and digital assets. So before the ISA 2025, you had a lot of forex traders who were seeking for monies from the general public, and there was no oversight. They were not regulated by the CBN and also not regulated by the SEC. Now, by virtue of Section 3 sub 3 O of the ISA, every online trading activity must register and be regulated by the SEC. Also, the definition of securities has been expanded to include virtual assets, and the SEC now has the power to regulate and register exchanges that deal with virtual assets. And finally, the exclusion of subscription money with respect to financial institutions. So now under the ISA 2025, where there's any purchase of shares and before allocation, such money must be held by a custodian and is different from the monies that are held by the bank. There's no mixture, such that only when there has been allocation of these shares that these monies are now transferred to the financial institution. What that does is that in the unlikely event of any bankruptcy, before allotment, the monies are separate and can also be returned very easily to the investors. So what we have done this morning is to take everyone through what the ISA provides for with respect to the IST, its original and appellate jurisdiction, and also 8 reforms that are meant to protect investors. Thank you all. Thank you so much.
Thank you very much, Mr. Iweze, for that illuminating presentation. Thank you for providing insights on the jurisdiction of the IST, as well as the highlights on the investors' protection, and most importantly, for pointing out the areas of conflict. And we see the interpretations that will be given to those provisions as time comes. So we're moving on, and we have next on the line a session by the Securities and Exchange Commission on compliance, governance, and regulatory risk. And I know a lot of people who have stayed on the call. Thank you for staying all the way up until now. So for this third session, we're supposed to have Dr. Emomotimi Agama, who is the Director General of the Securities and Exchange Commission, but unfortunately, he's not available. But he has sent a representative who is a member of his leadership team. And this session will explore the Commission's expectations from market participants and look at issues of compliance, governance, and regulatory risk. So for this session, we have Mr. Tafa M.C. Makio, who is the head of the monitoring department at the Securities and Exchange Commission. So Mr. Tafa Makio, are you in the room?
Yes, I'm in the room. Nsika, can you hear me?
Over to you.
Okay. All right. Good afternoon, ladies and gentlemen. Nsika has already introduced me. My name is Tafa Maiq. I head the monitoring department at the Securities and Exchange Commission. I have been asked to represent my Director General, Dr. Emomotimi Agama. And as most of you are aware, he's a DG who likes to engage. Unfortunately, he has a concurrent commitment at this time, so he's not able to be at this webinar. So he has given me the responsibility to present his paper, and his paper is on compliance, governance, and regulatory risk. So I will be presenting that paper, and I'll be reading the paper as prepared by him. So good afternoon, esteemed members of the Ernest Shonekan Centre for Legislative Reforms and Economic Development, distinguished ladies and gentlemen. It is an honor to address this forum, a gathering of the very individuals and institutions responsible for shaping our economy's destiny. Our collective purpose is to identify and drive the reforms that would unlock Nigeria's potential. My message today is a simple yet profound one. A modern, well-regulated and transparent capital market is not just a desirable outcome, it is a foundational pillar of sustainable economic development. It is the engine that will translate legislative reforms into tangible prosperity for every Nigerian. The recent enactment of the Investments and Securities Act 2025 is a legislative triumph and a testament to our shared commitment to reform. This act is not a mere update. It is a strategic piece of legislation designed to make our capital market more resilient, globally competitive, and supportive of economic growth. The new ISA 2025, the role of the Securities and Exchange Commission. The ISA 2025 is a landmark piece of legislation that modernizes Nigeria's capital market framework. It provides the SEC with enhanced powers to ensure market integrity and investor protection. SEC's expanded mandate under the ISA 2025. 1. Broadened scope. The ISA 2025 provides legal clarity and a regulatory framework for emerging areas like virtual assets, which are explicitly recognized and governed. This legislative action directly addresses a key economic while protecting citizens. By doing so, we are creating a predictable environment that will attract both local and international investment into a sector with immense potential. Strengthening enforcement and investor confidence. A key barrier to capital formation is a lack of investor confidence. The ISA 2025 gives the SEC enhanced enforcement powers, including stricter penalties for market abuse and fraud. This sends a powerful signal to investors, both large and small, that our market is safe, fair, and backed by a robust legal framework. When investors feel secure, they're more willing to commit capital to the real economy. 3. Focus on market integrity. The new law mandates key measures to enhance transparency and reduce systemic risk, such as the introduction of a legal entity identifier for all entities involved in financial transactions. This tool will significantly improve our ability to monitor the market and prevent illicit governance and accountability. The Act mandates stronger governance standards for public companies. It requires greater transparency, accountability, and fiduciary responsibility. These measures are not just for the protection of investors. They are essential for creating well-managed, sustainable companies that drive long-term economic growth and employment. The Act holds directors and principal officers to a higher standard, ensuring that corporate Nigeria operates with the integrity necessary to attract patient capital. Our role is to translate this legislation into clear, implementable rules and to enforce them fairly and consistently. We will use the powers granted under the ISA 2025 to curb systemic risk, combat investment scams, and ensure a level playing field for all market participants. Expectations from market participants. With this new act comes a new expectation from market participants. Number one, proactive compliance. The era of reactive compliance is over. We expect market participants to be proactive in their understanding and implementation of the ISA 2025 and its subsidiary rules. This requires investment in robust legal, compliance, and risk management functions within their organizations. 2, enhanced reporting. We expect timely and accurate filing of all required reports. The new act places greater emphasis on corporate responsibilities. 3, engagement and partnership. We invite market participants to engage with us. Our doors are open. We believe that a strong market is built on a foundation of open communication and collaboration between regulators and market participants. Regulatory risk and management, fiduciary obligations and sanctions. Regulatory risk is often perceived as a burden, but I urge market participants to see it differently. In a developed economy, a predictable and enforceable regulatory environment is a competitive edge. It is the bedrock upon which long-term investment decisions are made. I want to take this opportunity to assure market participants that the new ISA 2025 will neither disrupt their operations nor introduce additional costs. The SEC is committed to the federal government's ease of doing business policy direction. Fiduciary obligations. Market participants have a sacred fiduciary duty to act in the best interest of their clients and shareholders. The new act reinforces this by expressly criminalizing the misappropriation or misuse of clients' assets. This provision is a powerful tool to protect investors and ensure the integrity of our market. Market participants are obligated to 1, segregate and safeguard clients' assets. Clients' funds as securities must be kept in separate accounts and protected from operational risks. 2, act with professionalism and integrity. We expect market participants to avoid conflicts of interest, prevent market manipulation, and maintain the highest standards of professional conduct. 3, disclose and report irregularities. The ISA 2025 creates a powerful network of accountability. Sanctions. The consequences of non-compliance under the ISA 2025 are now more severe than ever. Sanctions can be administrative, civil, or criminal, and may include hefty fines. Fines have been increased to serve as a genuine deterrent, with some infractions attracting daily penalties for continued violations. Imprisonment. The Act explicitly criminalizes activities like Ponzi schemes with a minimum of 10 years imprisonment for perpetrators. Removal or probation. The SEC now has the power to remove principal officers and even place directors on probation, directly intervening to protect the integrity of a company's governance structure. ESG and transparency. The modern global economy is no longer solely focused on profit. It is driven by the principles of environmental, social, and governance. To attract the global capital needed for our nation's development, we must demonstrate a commitment to sustainability and transparency. Sex strategy. Positioning Nigeria for global capital. We are actively aligning our disclosure requirements with global standards, such as those from the International Sustainability Standards Board. This will ensure that Nigerian companies can produce reliable and comparable ESG reports, a prerequisite for many global investors. In this regard, the SEC is committed to the implementation of the roadmap for adoption of IFRS sustainability disclosure standards in Nigeria, driven by the Financial Reporting Council of Nigeria. Promoting green finance. We are focused on building a robust framework for green and sustainability-linked financing. This will enable capital to be channeled into critical sectors like renewable energy, sustainable agriculture, and climate-resilient infrastructure, all of which are vital for a diversified and prosperous economy. Transparency as an economic tool. The new ISA 2025, emphasizing on transparency and accountability, not just about regulation, it is about building a modern economy. Transparent reporting on ESG factors will empower investors, create greater public trust, and ultimately make our economy more resilient to future shocks. Market participants are expected to leverage technology to accurately measure and report on their ESG metrics, ensuring data integrity and clear audit trail. In conclusion, the enactment of the ISA 2025 represents a new chapter in our nation's economic history. It is the product of a collaborative effort between the legislature, the Securities and Exchange Commission, and the private sector. It is our responsibility now to ensure that this legislation achieves its full potential. My invitation to you today is for a deeper and more strategic partnership. The Securities and Exchange Commission stands ready to work with you to translate these legislative reforms into a thriving, transparent, and globally competitive economy. Let us together build a capital market that is not just a reflection of our economic aspirations, but a powerful engine driving our nation's prosperity. Thank you, ladies and gentlemen. So in second, back to you. I've delivered the paper of the Director General of the Securities and Exchange Commission.
Yeah. Thank you so much. Thank you so much, Mr. Matthew. I hope I got that right this time. I think I did.
Yes, you did.
Awesome. Thank you so much.
You did.
Okay.
Thank
you for your valuable insights. As a regulator, it's good to see how you're willing to interact with the players in the market. And I know that most importantly, once you have seamless processes for people to register license, it makes compliance a lot easier, which in turn eases the bottlenecks in the business environment. Thank you once again. So we would like to, at this point, invite DV, would be things for, which is on what legislators and policymakers must know. And this session is indeed important because we all know the importance of governance with regard to legal frameworks, implementation, etc. So I would like us to give a rounding applause to Chief Anthony Izigbe, SAN. You're welcome, sir.
Thank you so much. Can you confirm if you can hear me?
Yes, we can.
Okay, thank you so much. Thank you so much.
Yes, I can.
Thank you. I have been asked to speak on what legislators and policymakers must know. oversight, engagement, and enforcement within the context of the ISA 2025 reform. Just to share all the protocols that had already been shared, I'm really honored by this invitation by the Nigerian Economic Summit Group and the Ernest Shonekan Centre for Legislative Reform and Economic Development. I'm really very excited at this opportunity to share some of my thoughts on the topic. Generally, I would just have a short introduction. I would look at the policy purpose and policy objectives of the ISA 2025, and I would look at issues around policy legitimacy and accountability. I will then go into policy implementation. I'll talk about responsive regulation, and I'll deal with the issues of fines, fees, and sanctions under the ISA, and how the regulated actually see those things. And then I'll do a little bit of comparative analysis. I will talk about how we could maintain the balance, and I'll end with some recommendations. In terms of introduction, public policy really represent the intentions and actions of government. And why is this important is because there's a social contract, as we all know, that Thomas Hobbes said that if man was left alone, life would be brutish and short. And so people come together to establish government to protect their life and their property. And John Locke did extend that to property. Actually, it was just life and liberty that Hobbes spoke about. But John Locke said, also property. So what does that social contract involve? The social contract involves the transfer of power from individuals to the government. So they give government the power to control people's activities. And according to Emerson, who was my teacher, actually, regulation is an effort through government authority to control certain aspects of the private sector for a public purpose. So because we have transferred power to government, government then has the power to control, and they do this through regulation. And what's the role of legislators in this process? First, the legislators are people who are elected. So for them to be elected, they have to do manifestos. Then they do the policy agenda setting, and they go for mandate, through elections, and then they get elected. When they get elected, they are supposed to then pursue that manifesto or implement that policy, right? So they now go into policy formulation, which then leads to legislation and then regulation. And then after the legislation, they have to do oversight. That's why they keep inviting all the agencies and people for hearings or committee meetings, to perform the oversight functions. And then the purpose of the oversight function is to now reform the policy and implement it again, either through amendments, etc. So you see that whole process played out, leading to the Investment and Securities Act 2025. I had the privilege of attending the public hearing for that, and there was still a lot of contention between different stakeholders, in that whole policy process. Eventually, the law was passed, so we are grateful for that. So what's the policy purpose and the role of the SEC? The first one, of course, is to give us an efficient capital market. Essentially, the whole purpose of the capital market is to ensure the allocation of savings from the capital sufficient entities to the capital deficient ones, which is to productive activities. So basically, to take people's savings and put it into productive activities. And then also to ensure that there is adequate financial market infrastructure. I think the other presenters today have made excellent presentations on some of those details, so I won't go through it. Part of the policy is to also set standard of conduct. So these are just to ensure that we have an efficient capital market, whether it's the CCPs that was spoken about earlier, whether it's the exchanges, etc., or the CSCS and all the rest that have been set up to ensure that we can have an efficient capital market. Then the second policy objective is policy purpose is fairness in capital market transactions. So the system needs to be able to anticipate, identify, eliminate, and penalize unfair practices. And I think a lot of what we've spoken about addresses some of those details, so I don't need to go into it. The third one is public confidence in the capital market. So, and this is maintained through supervision of market participants' conduct. So you see the cases that have been cited, whether it's the Ajayi case, which was mentioned, although in the context of jurisdiction, but also it's relevant in the context of trying to maintain public confidence, because we spoke to the actions of the SEC in trying to enforce standards. So the other cases, whether it's the Cadbury cases, lots of cases came out from the Cadbury intervention, the Bokalan Union Registrar one, Oando one, and the Ikeja Hotel intervention. So there are so many of those. So in terms of the role of the SEC, it's been said there's an enhanced regulatory policy under the new ISA. It's expanded the legislative objectives, so extending it to digital, etc. A lot of which you've been told, strengthen the SEC as a regulator, and then the pivot towards financial market infrastructure, which you've heard, the improvement on the SEC power, insolvency carve-out, systemic risk issues, collective investment, private entities, public issue of securities, all that you've heard quite some details. So there's also the dispute resolution, which of course we've had a very fantastic presentation, detailed presentation by Vincent, right? But there's an ongoing case, the Omar case and the SEC case, where, notwithstanding everything that Vincent has said, an injunction, an order was gotten, a prohibition order, basically, that has circumscribed, if it were to be valid, the powers of the SEC to even regulate. So there are challenges, notwithstanding all what we've said. So the objectives, of course, of securities regulation is always access to information. For you to give your savings and allow somebody else to allocate it to productive activity, you need to have the information. You need to know what they want to do with the money. You need to know how they have been performing before, So that's why there are disclosure requirements, okay? And the question is whether the disclosure is going to be only at the time they take your money or subsequently on a continuous basis, right? So these are some of the issues that we deal with in securities market. Remember, they want to take your money, give it to somebody else to use it for productive activities. They need to give you information. So access to information is very critical. Fair play, you deal with it in terms of misstatements, fraudulent schemes, insider dealing, other unfair play rules, and how you respond to it. So this comment, because what we deal with in capital market is basically information. It's what you know about the company that gives you assurance whether the company is going to make profit and give you dividend, or whether they'll be able to pay the interest on your bond, on the bond they issue to you, or whatever securities, or whether if they give you a warehouse receipt, that at the end of the day, you will be able to sell the product, or somebody will sell the product and give you the money, right? So there must be standards and fair play. So qualifications and standards of conduct. So in this sort of circumstance where we are dealing essentially with information, right? The participants are fiduciary because they hold money, they hold other assets, they have knowledge, And so some other people don't have it. That is, the investors may not have that access to all that knowledge. So you have to set standards. You have to, there has to be qualification for you to be able to participate. And ethics will be a major issue, you know, and you have to exclude unqualified people, dishonest or incompetent people from the market. So other objectives is protect the market integrity through data collection. And we've been told about systemic risk and the rest. About how do you manage systemic risk? You need to get data so you can know what is happening. And then from the data, you'll be able to know when a company is already going bad. And then you can anticipate that risk and take actions before it actually goes bad. So that's the purpose. So it's all about data, even from the point of view of the regulator, trying to know what everybody is doing, how everybody is doing, you know, and then be able to determine their health. You know, it's whether they're healthy or whether they're becoming sick, whether they don't have cancer, you know, and things like that. But these are in financial terms, but the healthcare industry will give you an idea of what we are talking about. So in those circumstances, from the policy-making point of view and regulation point of view, every regulator has to battle with the issue of legitimacy. You know, people will always question, you know, the regulator, like, okay, what are you doing? Are you justified in what you are doing? So why should the regulator seek legitimacy? Because just like how the legislator goes back every 4 years to get the mandate of the people, that's what gives it that's what gives the legislator legitimacy, that the ultimate power in a democracy is supposed to belong to the people. So the people exercise that power every 4 years by electing the representatives, the legislators, who then act on their behalf. So same issue, the regulator also has to seek a mandate of justification. How do they do it? First, the constitutionality. First, it has to be constitutionally constituted. So you see the trace of the mandate, because the people in an election mandated the legislature. The legislature, in exercise of the people's power, created SEC. So there has to be that mandate, you know, coming from the people. The second issue is the rule of law. And the issue of rule of law is so important because the first issue is constitutionality, which that the Constitution is supreme and every power will come through the Constitution, right? The rule of law means that everybody is subject to the law. Everybody is subject to the law. Nobody is outside the law. And I cite some cases, you see, like the Orlando SEC matter, you know, no matter how powerful you are, that, you know, the SEC, if you look at all the other ones, right, Cadbury, you know, they are very powerful people, very powerful institutions, very powerful companies, very powerful individuals, right? But the idea is that everybody is subject to the same rule of law, whether you are high, whether you are low. You can see the simple, although this is not a capital market matter, but if you take the Bobrisky matter and the impact it has had on people spraying money at parties, just one action, right? Trying to say everybody must be subject to the law. Everybody has sat up now. You can't spray money anyhow, right? So that's the issue of rule of law, that everybody is subject to the rule of law. The other issue is the regulator. Part of how the regulator can get legitimacy is through a consultative approach, that before they come out with issues, they consult with the people. You can see they went through that even in terms of how the ISA was, this new ISA was created. They involved the legislators, they involved the market participants, there were retreats, everybody made their input, and that's why you can see when it comes to implementation, it was easy to start the implementation. And this very process we are going through, as has been said earlier by some of the facilitators, that is part of that consultative approach, education, getting people involved. And we're happy to be here to also talk about it as part of that consultative process. This is what gives legitimacy to the regulator. But the other part of it is accountability. So the question is, who regulates the regulator? That is always what we, when we talk policy and regulation, you always have to answer this or deal with the elephant in the room. Who regulates the regulator? And so you then begin to go into it, and then you see that, for instance, the National Assembly has the power to conduct investigations, etc. They call it oversight function. If you look at, I think, Section 87, 88 of the Constitution, it gives that power. That's why they always call every agency to come, etc. But the purpose of that is not really to now start controlling the regulator, but is they call the industry, they call everybody so that they have a feedback on what is needed. And then they can then allocate resources, either pass new laws, allocate a budget, make sufficient budget and the rest for that particular sector, etc. So there are times the law may provide that every year there should be a report sent to the National Assembly or etc. But you have to balance it against our trying to comply with ASCA requirements of independence for the SEC. So we've tried to make that balance. So those reporting obligations, like there was the one where the minister could give directions and the rest. So we had to amend that aspect to make sure that there's a balance between independence and reporting, right? Etc. So there's reasonable scheme for accountability under the ISA 2025, whilst maintaining the independence of the institution. So policy implementation becomes a major issue that, okay, so how do we implement it? So this is an old slide I decided to put here because it's so good. It's done by Braithwaite and Harris. They are Australians, and they wrote this wonderful a book on work. They did this wonderful work on enforcement, and they spoke about enforcement pyramid, and it talks about that at the bottom of the pyramid, you use persuasion and education, you use negotiation and settlement, you use investigations, inspections, and examinations. Then you issue notices, letters of warning, and fines. And on top of that, if the people don't obey, you then go to civil pecuniary penalties, remedial civil law-based remedies. And then depending on what the policy objective is, you want deterrence and the rest, you begin to look at criminal pecuniary penalties, management banning orders, removal from offices, then imprisonment at the very top of the pyramid. So this is the enforcement pyramid developed by Braithwaite and Harris. So, however, there's this challenge between deterrence and an accommodative policy, in policy implementation. And the funny thing is that Braithwaite now did further study and said, well, that enforcement pyramid gives the wrong impression, right? So they came up with another concept we call responsive regulation. And under responsive regulation, they say, don't look at the pyramid as like once you get onto it, you are going straight up to the top, right? So they said they developed a heuristic, 9 heuristic responses, that you can use as a regulator, to deal with those issues. Firstly, that you think, and don't impose preconceived theory. So don't always, the regulator shouldn't have preconceived theory. They should always think through issues. They should listen and actively structure dialogue. So stakeholder consultation, implementation of agreed outcomes, commitment to motivation to improve communication. Then they should engage skeptics, those who don't believe. you know, you engage with them, talk with them, right? And those who are in your support, you know, those who are committed, praise them, support their innovation, nurture their motivation, help to pull laggards up. Okay, so there are times you give awards to champions and things like that. You know, those who are supporting you, you go with them. So there's signal support to outcome through education and capacity building, right? Signal escalation of the pyramid only as a last resort. Okay, so engage in a wider network of partners as you move up the pyramid, and then there should be a client active responsibility. So you push a lot of things to the regulated to do, okay, and learn to evaluate the cost of what is achieved and communicate lessons learned. So those are the 9 heuristics that they suggest. So this is how the pyramid then looks if you use the responsive regulation approach. Okay, so what I want you to look at is, you will see on the left side of this pyramid, you see escalation. You escalate. It talks of when you need to escalate, but it talks about de-escalation. So you don't have to always move upwards the pyramid. You have to know when to de-escalate. Okay, and so it gives you an idea where, you know, you encourage voluntary compliance, you do informal resolution, you do administrative action, or the civil or criminal ones that we mentioned at the top of the pyramid. But the point is that what they are saying is that if you're voluntary, if there's voluntary compliance, then you de-escalate, you don't go up. Okay, or if there's not, you move towards informal resolution. If you can resolve it informally, you de-escalate. Okay, if it's not resolved, you go to administrative action, like administrative fines and the rest that was mentioned, right? But if that is enough to solve the problem, you de-escalate. That's what is called responsive regulation. So in reviewing the ISA 2025, I decided to speak about a major issue you see in regulation and policy, which is fines, fees, and sanctions. I will tell you that from all the studies, looking at the studies of so many people like Kota, the regulated actually see all these things as prizes. So the incentive effect of prices and sanctions, they are different. Okay, so non-conformity could be advantageous and cheaper, according to Kota and many other studies. So ISA, for instance, stipulates fixed fines and penalties. I mean, we've been told about them this morning / afternoon, right? And they are fixed fines, and the only variable is the number of days, you know, 50,000 per day of violation. Now, if you factor in inflation may erode the value of the fines, making it cheaper to breach, you know, than to comply. So there's an efficiency theory about fines, you know. So the regulated see fines, fees, sanctions as prizes. So there's a need for the regulatory and legislative focus to focus on the value of loss or damages. So that's one of the problems that I see from the ISAs, all about fines. You say 10 million, it looks high today, but tomorrow it may not be a very high amount of money, and it will not be a deterrence. So there was that talk that, oh, maybe this will be a deterrence because it's 10 million. But the regulators see it as a price, and it may be a very cheap price by tomorrow. So you look at comparative analysis just for us to get a landing on some of these issues. The US model, what they do there, once you have regulatory action by the SEC in the US, and they use all those techniques, fines, blah, 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 they have robust what they call right of private action, you know, which enables the individuals affected to sue directly for violation of securities law, rather than relying on the public regulator to be the ones to do it. So then to make it very, very profitable for individuals to sue, they have the triple damages provision, where triple damage compensation is applicable in some egregious cases. Now, this framework significantly deters misconduct and supplements regulatory enforcement. Also, regulators, through trustees appointed in cases of Ponzi schemes, can seek clawback from early-stage investors who receive unreasonable profit and become foot soldiers for the fraudsters. This policy deters Ponzi schemes because if you invest in a Ponzi scheme and you make a lot of money, unreasonable money, because you are one of the early people, and for you to make the money, you have to recruit new people to pay. As they pay, you collect your own. Then you have become part of the scheme. So you must be told to regurge some of that profit so they can distribute it to those below, because it's a pyramid scheme. Those who are later investors who will lose out 100%. So they too can get something. We pushed for this to be in the law. For some reason, it was knocked out. We still think that the policy objective hasn't been achieved, so it needs to. When I come to the other slide, you will see what the views are. I looked at the situation in the United Kingdom, in Canada, etc. And I'm saying that a lot of the tools, for instance, a lot of the tools that they have in America, which are these pre-action tools like search, sanctions, etc., are now available. They are available under the ISA 2025. So it's a big improvement, big lift from 2007. However, there are some of these things that are still not there. Yeah, so I did some other reviews of United Kingdom and Canada, but to save time, I speak about maintaining the balance in policy oversight, engagement, and enforcement. So I look at it from the point of view of the regulator and from the point of view of the legislator. So for the regulator, well, I have suggested responsive regulation. So apply a medley of civil and criminal sanctions, use consent orders, settlements, and undertakings, escalate and de-escalate on the enforcement pyramid as necessary, engage in collaboration and cooperation with the regulated on enforcement. Okay, one thing that is very important for the regulator is consistency in implementation and enforcement. The rule of law issue, which I've mentioned earlier, very important for your legitimacy. So then the other one is do research and collaboration with the private sector and the legislature on regulatory innovation. So for instance, the NESG and the Shonekan Centre is a good example. So I think that what we will take away from this engagement is the next stage. So what's the research and collaboration that we need to do to move to the next stage? So some of what is done is, for instance, in the fintech one, as you know, before this law, there was the fintech association, did come up with what they call the sandbox, shared with the SEC, that this is part of how you develop new regulations, where the private sector would come up with a sandbox and say, well, we think this is how it should be done. And then they look at it over a couple of months or years, and then now decide, okay, this is how we will regulate. And then the regulator will say, this is the position we'll take. So those sort of systems need to be in place between the regulator and the regulated, driven by private sector initiatives such as the Shonekan Centre or the NESG and other significant private sector institutions. So for the legislator, I think that they need to respect the independence of the, for the legislator, they should respect the independence of the regulator, okay? And then they should maximize their oversight, constitutional oversight function to give them policy insight. It's not an opportunity to harass the regulator, right? It's an opportunity to get feedback from the industry, what the problem is, what the challenges are, how it can be solved through legislation, right? So then to generate innovative legislative outcomes timeously and efficiently, right? And then to allocate resources for effective policy implementation. So when you see where the loophole is, why is it that we are not getting results on Ponzi schemes? Why is Ponzi scheme losses getting higher? the legislator would do an oversight on it and now say, okay, this is the solution. They will pass the law, allocate the money, etc. So then there should be absence of interference with the work of the regulator, because that's what one of the biggest problems you can have in every system, where the legislators feel we have the power, then they are intervening every day, then that affects rule of law, lack of consistency, then you lose legitimacy as a whole, as an entire system. So you can see that if everybody plays their role, that the implementation of this policy will be seamless. So to maximize the impact of the ISA 2025, Nigerian policymakers should consider the following. One, embrace regulatory diffusion. And by this, I mean a new approach. This was developed by somebody, I didn't put his name here, Fever Lapo. Essentially, it spoke about regulatory diffusion as a new approach, right? Where the regulator associes a lot of the regulation to the private sector, empower them to do a lot of things, but within the wider concept of regulatory diffusion, one of them is to use private action. Okay, and that means triple damage, for instance, clawback provision, market cap policies. For instance, if you look at the FCPC law, if there's breach of antitrust or competition issues, now they tie it to the market cap of the company, and that's why the damages can be quite large, right? So that way, we think that there will be sufficient flexibility in the financial deterrence. So if you just tie it to a fixed amount, 10 million, as I said, inflation will wipe it away. But if you tie it to, let's say, triple damage, a clawback of profit, market cap, such things, will make sure that the law is flexible enough to deal with the actual situation. So I think outsourcing regulation to the private sector entities through various means, will improve enforcement and monitoring. Strengthen the oversight committees, okay, through continuous engagement with the industry, adequate resourcing of the SEC, and strict ethical standards. Institutional stakeholder consultation, I think I've said so much about it, and leverage on education and public enlightenment. Enhance sex resources with sufficient funding, advanced surveillance technology, and specialized personnel to handle complex financial crimes. So you need to allocate resources as a legislator for this to happen. So you can have nice, beautiful law, as we think we have achieved, but without the resources, without the funding, which will come from the legislators, because you have the power of the purse, it will not be effective, really. Then the other issue is the IST. I mean, Odiaka gave a beautiful presentation on the IST, but I've told you there are serious problems. At the end of the day, I told you about this Omar versus SEC case, very recent. The problem is IST is not in the Constitution, right? And when we were doing the ISA, the idea was that constitutional amendment was too vigorous. It would take too much time and will not come out with a law. So we knew it was a stopgap measure. But now that I have the opportunity to speak to the legislators in a legislative forum like Ernest Shonekan Centre, we need to direct the attention to now go and put the IST in the Constitution. That is the real solution to the problem, right? Just like the National Industrial Court was successfully put in the Constitution. And then maybe they can consider an appellate panel of specialists, because even the Court of Appeal judges, when at the last judicial workshop, they were complaining that they don't have enough knowledge, but they think if they have another panel of real experts who can take appeals from the IST to make it easier, and then maybe from there it just goes straight to Supreme Court or something if you need to appeal for that. So we need to consider that. So, conclusion, I just say that the ISA represents a bold step towards modernizing the Nigerian capital market and bringing it closer in alignment to international standard. And I think the other presenters have already dealt with the details of how it has expanded to digital assets, FMIs, and the rest. I don't need to talk about that. So a lot has been achieved by the ISA, but all I can say is that as market innovations are constant, and the ISA 2025 has attempted to address many of these new issues, so also must the legislator, the regulator, and even the private sector continue to innovate on regulation. Now, the modern shift is towards regulatory diffusion, as I've said, with the private sector, such as the NSG and Shonekan Centre, taking the lead to provide sandboxes for regulation. The legislators, through their own oversight function, should consult and monitor with the market to enable it to update the laws, ensuring that it is always able to cope with the rapid pace of innovation in the capital market. Thank you.
Wow. Thank you so much, Chief, for that very insightful. In fact, I think I've gained a lot of knowledge just listening in on that, particularly with how the National Assembly, the State House of Assemblies, can all interact and collaborate with stakeholders. And I think that's something that we are big on here at the Ernest Shonekan Centre. We have as our pillars, capacity building, ensuring that we carry out technical assistance and support to the National Assembly and State Houses of Assembly. So thank you so much. We've come to a very critical point, which is the interactive Q&A. And I guess this is where a lot of people have been waiting for. We have a chat box, so you can insert your questions in the chat box. However, if you would want to speak, please just raise your hand and we would unmute for you to speak for just a minute or two. So the floor is open to our audience, who I must thank immensely for staying on all the way to the very end. So do we have questions? And the questions can be for any of the sessions we've had so far. I guess there's a lot to unpack with the ISA, so people are still trying to determine what to ask.
Hello, good afternoon. Can you hear me?
Yes, we can. Please go ahead.
Hi, good afternoon. My name is Samuel Salako. I'm a partner in Daily Piper, Africa, Nigeria. Now, to Chief Idebe's presentation, very lovely. And I share the belief that a lot of the infractions and fines that are paid are actually factored into the business. What I think should be happening is that there should be indicative personal liability of the directors or people responsible for some of these infractions. In transactions, we know that when you do your transactions, you take out insurance. Insurance can take care of these liabilities. But I think if we have people personally liable for some of these damages or fines or penalties, I think it will go a long way in actually ensuring that there's a considerable level of compliance, and we're not looking at it being factored in as a cost of the business or additional cost for insurance, because the way it is right now, what we find is that ultimately the investor bears this cost of the penalty. If a company is fined, that's to reduce profitability. If the company is taking it out of insurance, that's from the premium paid from the money available to the investors in the first place. So you don't see that personal liability or responsibility, for the people who actually took actions leading to these infractions in the first place. That's my contribution. Thank you.
Sorry, do we wait for others, or we take it one by one? Second. Do we wait
I
for
think
other
we can.
other contributions, or we take it one by one? Yeah.
I think we should take it one by one because we don't have any other comment for now.
Yeah, okay. So, Mr. Salako, I agree with your comments. In the comparative analysis that I made in the US, that discipline in terms of personal liability is run mostly through private action, that triple damage, and most directors are always worried about the fact that they can be sued. So the typical one, for instance, if you the typical court cases we see in US and Canada is, let's assume that you mismanage the company in a way that the share price drops because of the mismanagement. The shareholders are likely to sue the directors for the loss, and because they know if they succeed, then they'll get triple damage. So let's say if the loss is $1 million, they will get $3 million. So that's enough motivation for them to sue. And that's enough motivation for directors to be consigned in those places. And that having been said, one solution there also is the outsourcing of that risk. And the typical way it is outsourced is through directors' risk insurance. So most people will not agree to become directors in US companies or Canadian companies, and increasingly now Nigerian companies, without the insurance being in place, just in case, because of that risk of personal liability. But I think where the problem is whether the legislature has sufficiently incentivized the Nigerian shareholder to be the forefront of implementing that policy of discipline by those who manage the company. I think they are leaving it too much to SEC, and that's part of the problem. But if they have this triple damage solution, it could assist in shifting the enforcement towards private action. Thank you.
Thank you very much, Chief, for the response. So we have a question from Mr. Adenuga. Mr. Adenuga, you have the floor.
Okay. Thank you very much. Thank you, Chief, for that. My name is Tony Adenuga. I'm a partner in the law firm of Birchstone and Grace. This has been a very insightful session. And on the point about fines and penalties, and one thing, because I used to be head of rules and adjudication at NGX, I was fortunate to attend IOSCO's seminar some years ago in Zurich. And I raised the question there about fines and how deterrent they will be. And because I raised the point about how from time to time people in Nigeria commit infractions and they don't really care. They are ready to make payments and they may even commit more infractions. So the point that was made there, which I think the NGX has continued to follow up until when I was there, and I think they still do, is that continue making the fines deterrent, because at the end of the day, you have to keep doing things to make sure that the market, market is properly run. On the point of triple damages, I do also recall that the NGX has rules that ensure that where you, as a result of your commission of infraction, you make maybe a profit or a gain, you are made to pay, 3 times that as a penalty back, to as way of punishment. That's my contribution, and I don't know whether Chief has any response to that. Thank you.
Thank you. Thank you so much. The only thing I would say about the NGX, and I respect the fact that you worked in the NGX, is that the NGX is a self-regulatory body. And I remember one of the theses I wrote, I dealt with that issue about in the context of policy and regulation, the role of self-regulation. Actually, if you look at the history of capital market in Nigeria, it started with the Nigerian Lagos Stock Exchange as the sole regulator. And then later, the CBN came in with the Capital Issues Commission, which later became the Securities and Exchange Commission, and then transformed into a statutory organization. And the question, and there's been a lot of research about this issue, is why is self-regulation inadequate? You know, in my comparative analysis here, I spoke about some other systems like Australia that uses a lot of self-regulatory bodies, like Canada that uses a lot of self-regulatory bodies, you know, but then there's always supplement of statutory regulation. And that's because of two things. One, the self-regulatory body is made up of the members, you know, the members whose self-interest at times overcome the interest of the society. The second weakness of self-regulatory bodies is that they don't have the coercive power to actually implement, which a statutory body could have. So for those two reasons, self-regulation has been, in most systems, inadequate to deal with the situation. So whilst it's possible that the NGX may have some of those rules, but if you've ever engaged, and we are in the industry, right, in different capacities, as a shareholder, which I am, quite an active shareholder, as a corporate director, as a lawyer, so I know the system very well, and try to send a petition to the NGX and see what happens. And then you see people running to SEC and running to different places. So it's old boys club, you know. So I'm not saying, I know that the NGX has done a lot to put pressure, and their standards are extremely very high, but it's still a self-regulatory body, so it has that limitation that at the end of the day, there are some things it cannot do, you know. And we've done cases many years about, you know, situations where there will be like stop trade order, and there will be difficulty about implementing it, you know. And I've never seen the NGX fight its members very strongly, let's say in court, even when there is statutory orders against them. So they basically just stay behind quietly as what it is. So we can make some changes, because I know that in Canada, the self-regulatory bodies are very strong. They act almost like regulatory bodies, like statutory bodies, right? And everybody is afraid of them. And they are so afraid, they don't want any action against them as an institution by the statutory bodies, that they make sure their members keep to the highest standards. So I think there can be some improvements in self-regulation in Nigeria, and that will help. And in fact, the essence of my paper is that there should be a diffusion, so that the statutory regulator does less, the self-regulator does more, by diffusing regulation downwards, not upwards, as we are seeing in Nigeria, which has made SEC too busy. SEC is handling every little issue of 5,000 shares. It goes to SEC. Why is it that the regulatory bodies can't deal with all these things, that everything is going to SEC? It's overwhelming. So we need to diffuse, come backwards, and get the regulatory bodies to do their job. Thank you.
Thank you, sir. I'm sure SEC is listening.
Yes, we have people from SEC on the call. Thank you so much, Chief, for... Oh, yeah, there he is. Maybe we'll let you make some comments, Mr. Makiu.
I agree with the comments and suggestions that have been made, but I am sure Chief will remember this, that we have tried this in the past and Chief will remember the case of Oando. The penalties were not just restricted to the corporate entity. We identified persons, and the penalties were also imposed on directors. Of course, it ended the way it ended, but I'm saying that we have attempted this in the past to hold directors responsible and to ensure that where directors are, where penalties are imposed on directors, the entities are then, they don't find a way of getting the entities to then pay the penalties, because it then defeats the purpose of imposing the penalties on the individuals. So we have done this in the market. Perhaps we need to do more so that, and I guess with the ISA, ISA 2025, we'll be seeing a lot of this happening. That penalties and actions will be taken against directors individually and be held responsible for some of the perhaps some of the issues that we're contending with now would reduce, because individuals will then know that they will be held personally liable for some of their actions. Thank you.
Yeah, thank you, Mr. Makwa. Just to say that, yes, that was why I put the Oando one under rule of law. And it was a success. We achieved a change of behavior, which was the regulatory objective, and those consent, that was a consent order or was a settlement, but it was one of those three issues I mentioned. They were complied with. It was a negotiated solution, and we de-escalated it as soon as we achieved compliance. So it was a good example of the responsive regulation, in spite of all the challenges, the legitimacy issues, the power issues that were at play. At the same time, the regulatory objectives were reasonably achieved in that case, yes. And we had a change of behavior strategy, which worked out, and it was even in the midst of litigation and all sorts, and yet we were still able to resolve the matter and then use consent orders to deal with the litigation. And it was a complex transaction, but it was achieved, and I put that was why I put it when I was discussing legitimacy, because if you cannot, as a regulator, be consistent in your regulation, and there are some people who are now above board, then you will lose legitimacy. And that was, I gave that as an example to show, yeah, even though I didn't go into the details, but you're right. Thank you.
Okay, thank you so much. Do we have any other question? I don't see. Okay, it is a question. I see. Let's see. Okay. Okay. So Franca says she had questions directed to her on the chat and she has responded to them. I think they were sent to her directly. Okay, that's fine. Do we have any other person that would like to say a word or two before we move to the final session? Okay. Okay, so with that, I would like to thank our panelists for a wonderful, wonderful session. Thank you so much. Please, can we just give them a round of applause using the tool we have here, just the reaction to thank them. I think they've done really amazing work. Thank you. Thank you. You covered the field, as I would say. So I would like to, at this point, invite our senior fellow, curriculum development, Mr. Dr. Chukwuemeka Azinge, who will share some conclusion of what we've done so far and provide highlights of today's event. So Dr. Azinge, over to you.
Thank you very much, Nsika. Thank you very much. Ladies and gentlemen, distinguished colleagues, esteemed practitioner, what an intellectually invigorating and enlightening morning that we have shared. On behalf of the Ernest Shonekan Centre for Legislative Reforms and Economic Development, I want to extend our deepest appreciation to our exceptional speakers, panelists, and you, the distinguished members of our audience who have engaged with rigor, curiosity, and candor in today's discourse on the ISA 2025. Ms. Franca Egwekwe began with an incisive legal exposition that laid bare the structural recalibrations of the ISA 2025. She guided us through the Act's expanded treatment of digital assets, the tightening of capital market infrastructure governance, and the recalibrated enforcement mechanisms of the Securities and Exchange Commission. Importantly, she reminded us that the ISA is forward-looking, built to anticipate and accommodate the evolving contours of the global financial market. Mr. Odiaka Vincent Iweze brought the judicial and procedural dimensions to the forefront, emphasizing the strengthened tribunal jurisdiction, streamlined adjudication processes, and enhanced whistleblower protections. His analysis highlighted that investor protection under the new act is not only aspirational, but also institutionalized, enforceable, and backed by a more coherent rights-based architecture. And we had the head of operations from SEC representing the Director General, anchoring the conversation in governance, operational ethics, and market discipline. He challenged market operators to move beyond technical compliance into an internalized culture of integrity, ESG accountability, and also proactive risk management. His remarks underscored that regulatory reform succeeds only when institutions embody the spirit and not just the letter of the law. Chief Anthony Idigbe, Senior Advocate of Nigeria, bridged legislation, policy, and governance, making a compelling case for legislative literacy among market institutions. He spoke to the strategic importance of sustained oversight, structured committee engagement, and collaborative policy design, reminding us that laws live or die in the quality of their operational and political environment. His insights reinforced the need for continuous dialogue between policymakers, regulators, and market actors to ensure that reforms take root, especially the need to explore how we can put the ISA in the Constitution. From these rich perspectives, 4 enduring anchors emerge. 1, the ISA 2025 is an instrument of national economic strategy, not just a regulatory update. Its provisions are designed to deepen markets, integrate Nigeria into the digital economy, and build durable investor confidence. 2, effective implementation requires clarity of role and purpose among regulators, market operators, and lawmakers. Overlap and duplication will only weaken the law's impact. 3, the private sector must be a co-author of Nigeria's regulatory culture, shaping enforcement realities through sustained advocacy, innovation, and partnership. And 4, capacity is the true currency of reform. Without the skills, systems, and institutional readiness to operationalize the ISA 2025, the law remains a blueprint without. Colleagues, I dare say today was the roadmap. September will be the test drive. In September 2025, the ESA will convene a post-webinar capacity development seminar in Abuja, also hybrid, purpose-built to transform the ISA 2025 from an inspiring piece of legislation into a living operational reality. The seminar will translate the Act's provisions into institutional strategies for compliance, oversight, and governance, stimulate legislative harmonization exercises to align subnational frameworks with national investment objectives, run enforcement and dispute resolution case studies, allowing participants to apply the Act's mechanisms in realistic scenarios. It would also mark the official launch of the ESA's Practitioner's Guide to the ISA 2025, a practical living reference distilled from today's insights and the outputs of September's seminar. Reform is not only realized in the signing of a bill, it is built in the day-to-day decisions of those charged with making it work. I therefore urge everyone, do not let this momentum of today fade into polite recollection. Register now for the post-webinar implementation seminar by contacting our secretariat. The conversations begins here, but the transformation begins there. In closing, I'd like to thank our speakers for their brilliance, the ESC Secretariat for their meticulous organization, and you, our network of experts, for your commitment to a stronger, more competitive Nigeria. As Justice Louis Brandes observed, the logic of words should yield to the logic of realities. The ISA 2025 gives us the words, together, let us build the realities. Thank you very much for your time. God bless us all. Thank you.
Thank you very much, Dr. Zenge, for giving us a detailed summary of the session. So with that, we've come to the end of today's webinar, but we would please ask that you fill the feedback form in the chat box so it could help us improve and also see the areas that you would also like us to address in the future. Thank you.